Ethics. And our panelist, Justice Indu Malhotra, retired judge and senior counsel of the Supreme Court of India. Is Justice Indu Malhotra around? Sir, I request you to please be on convene the dais. Mr. B.L. Vora, retired Director General of Police. Dr. Neeraj Nagpal, Director, Hope Gastrointestinal Diagnostic Clinic, Chandigarh, and Managing Trustee, Medicos Legal Action Group. Mr. Siddharth Luthra, Senior Advocate and former Additional Solicitor General of India. Dr. Ravi Mahajan, Director, Critical Care Integration and Transformation, Apollo Hospitals. Requesting Dr. Ashwini Kumar, sir, to kindly proceed with the session, please. Thank you.
Good evening, ladies and gentlemen. Thank you, Vicky Heel, Anupam, and Harsh Mahajan for giving me the honor of the podium. And it's my pleasure to host this discussion for a very erudite, accomplished, and esteemed panel, the members of which have already been introduced to you. So I would, without wasting much time and without much ado, I'll start with setting the context. I think I'll take the podium there. The current picture is that doctors are covered under more than 90 different laws, acts, and applicable regulations. They require more than 54 different permissions to start practice. Unfortunately, they can be prosecuted simultaneously in more than 12 different courts and platforms, including consumer courts, criminal courts, civil courts, human rights commission, NMC, and now even under Clinical Establishment Act. The medical cases form the top 5 sectors in national and state consumer dispute redressal commissions. There is a sharp rise over the last decade in medical malpractice cases, and you can gauge that the number of complaints have doubled in Delhi Medical Council itself, 3 complaints every 2 days, 3 new complaints every 2 days. I am pained and anguished to project this picture because of the spot justice done by the relatives of the patients and the violence against doctors and vandalization of the healthcare establishments. This is the recent pictures. I would not go through the slide completely. Suffice it to say that at any given time, on an average, each hospital in the country has been or is involved in 0.6 consumer court cases decided or pending at any one time in the consumer courts. But more important is that out-of-court settlements are approximately twice the number of the cases, which means at any given time, any average hospital or nursing home or clinic is grappling with at least 2 cases at any one time. With the passage of BNS, we find something else, and that is, for the first ever time, medical negligence has been specified to be brought under section 106(1), which is death by negligence. In the erstwhile IPC section 304A, the punishment was imprisonment for a term which may extend to 2 years or with fine or with both. However, under the current law, the imprisonment and fine, both are mandatory. In the same law, in the same code, section 117(1) and section 124, which cause permanent disability or persistent vegetative state, which cover permanent disability or persistent vegetative state that attracts a punishment of 10 years, which may extend to life. Those of you who are doctors here, and those otherwise also the hospital administrators, we know that permanent vegetative state may occur after a patient who suffered cardiac standstill is revived, and it is very common occurrence in most ICUs. There is no way for the doctor who is attempting to revive such a patient to know beforehand whether he will be able to successfully revive that patient or whether the patient would suffer a brain damage with permanent vegetative state. That brings us to another critical area, which is end-of-life care, because there have been recent changes and some procedures have been simplified. But we need to discuss what are the associated dilemmas. And are doctors supposed to play gods when it comes to withdrawing the plug? And what is the current state of laws governing? And I cannot escape mentioning the all-pervasive social media today, because we use it as telemedicine platforms. The sensitive personal data protection and security breaches are a concern for everyone. Ethical aspects, when we use this as revenue generating platform for manipulated and engineered reviews. By that I mean you pay to buy good reviews and you pay to buy bad reviews for your competitor, for trolling by patients. So, ladies and gentlemen, without much ado, I would start my question. If I may be permitted, can I use this podium rather than coming there? I would start by asking the wearer where the shoe pinches. Dr. Ravi Mahajan is Director Critical Care Integration and Transformation at Apollo Hospital, Chennai. He has been President of Medical Protection Society in England also. So, Ravi, what are the legal problems and challenges that you face day to day in your experience in your hospital?
I'm not sure whether it's working.
Take that one. Take that one. Yeah.
It's probably. Can you hear me now? Yes. Brilliant. Thank you. No, thanks very much. Thank you, Ashwini. I think, let me just step back a bit and look at the whole context. When we say that somebody is to be blamed for something that's gone wrong and somebody must pay for it, that is the premise in which the medical legal world works. So you prove the negligence. If you've proven the negligence, then somebody carries the can and somebody needs to be blamed. We heard in the last session, it's question of trust and it's question of building trust. And when we talk about trust and building trust, we heard various reasons why the trust has broken down between the healthcare provider and the one who's receiving at the receiving end. And that, as you mentioned, then gets fueled because we live in the blame culture that every mishap has to be attached to a blame. That's then taken in form of violence or medical legal action, fueled, rightly sometimes, but mostly wrongly by media, exploited by local politicians, the local and also other politicians, and I must say misunderstood by society in general and also by law. I can be provocative there.
Yeah, would you briefly elaborate on that, you said?
If you look at the healthcare outcomes, we heard in the last session, and if you were to look at the root causes of healthcare outcomes, the negligence plays only 1% of the part. 99% of the times, nobody gets up in the morning and thinks that I'm going to do something wrong today. 99% of the times, right people are doing the right job and things happen to go wrong. Mm-hmm. And sometimes it's unknown. You just don't know unexpectedly. Things may turn in a way that things can go wrong. Or you can expect sometimes that the things can go wrong, but the perception by the patient is that everything will be all right. So there could be misconception between the healthcare provider and the healthcare receiver. Now, what do you do if things go wrong? in an ideal world, you like to do root cause analysis, look at why things went wrong. Was the process okay? Were the structures okay? Did we do the right thing for the right patient at the right time? If the answer is yes, then there is nobody to be blamed. If the answer is yes, some processes could be done in a better way, then of course hospitals and healthcare providers should improve on the processes. But the answer is yes, there was medical negligence on part of a doctor or a nurse or a healthcare provider, then of course there are ways of addressing that.
So you mentioned about the medical malpractice or medical negligence. What are the other challenges, legal challenges that you face?
Well, I think lots of challenges are to do with the processes which are very, very immature, I would have said. You know, the whole process of building trust. You know, how are we informing our patients? Are we getting the consent in a way that it should be, taken? Are the insurance claims, our billing system, is it transparent enough? Is it well understood by the insurance claim? Why is it that 50% of the insurance claims are either not paid or they are paid less than what the billing is? So there are things that hospitals can do and should do, and some hospitals are better than the others. Regulations you mentioned, but then also statistics would tell you that only 13 states in our country are complying with even the basic regulation, which is the Clinical Establishment
Well,
Act.
I'll correct you there. There are 11 states only, not 13.
Okay, so 11.
And all the union territories excepting Delhi.
Yeah. So there you are. End of life care you mentioned. 70% of patients die in hospitals. And how many hospitals have proper end of life care protocols? How many of us actually have palliative care within our systems? And I think those are the things, when I say hospitals, it is the society. Society has to own up. And they have to understand that death is a natural phenomenon. It occurs, it happens, and it has to have in a dignified way. Training of our own hospital doctors and nurses and everybody in all these matters of medical legal. We know that 70 to 80% of graduates from medical schools or medical colleges have very little idea about the processes that I've just mentioned regarding informed consent and other things.
So do you find that as a challenge?
Well, it is a challenge because when these people come and work in the hospitals, it is up to the hospitals and the nursing homes to actually make sure that they are well trained. And if they are not trained, it takes some time and they are already in employment. So handling issues is another thing. How do we handle issues? Something's gone wrong. What do we do? Do we hide it under the carpet, or how many hospitals have mortality reviews, as for example? Do we look at deaths? Do we look at why something has gone wrong or something has happened? What can be improved upon? I think if we are a bit more transparent as society about this, and when I say society, it's not just the healthcare providers, but the patients, the politicians, the media, everybody has a role to play. The legal system and the law enforcement system has to play that role. So the culture has to go from being a blame culture to learning culture.
So of the challenges that you just mentioned or listed out, what do you think is the most challenging one? Most challenging?
I think something that you can't control. I think most hospitals, as you know, can control the training, the accreditation process, getting the structures right, getting the processes right. You can't control violence. I think if that is a societal issue, and somebody mentioned that very clearly, you don't trust the doctor or the hospital, you feel that you've been cheated, and you don't trust the legal system because you think you go there, your case will be pending, so why don't I do something now? And that kind of violence, which is then fueled further, sometimes by media, sometimes by inadequate law enforcement, I think that is a challenge because as a hospital administrator or as a doctor, we are in a society where your position the power of your position is judged by the number of bodyguards you have. So, which is a paradox in itself. So if we are in that kind of society, how many doctors would have bodyguards around them? How many hospitals will have security, guards guarding the hospitals? So these are easy, vulnerable targets, and that is a big challenge.
Right. So let me just surprise and shock the audience by saying that violence against doctors and vandalization of the healthcare establishments occurs with sickening regularity. Would you believe that every half an hour in this country, either a doctor is beaten up or a healthcare establishment vandalized? So I would like to ask Neeraj this. Do you think it is just limited to India or is it a worldwide phenomenon?
Taking you one step back to what the gentleman in the previous panel discussion said, I think I love to speak on behalf of the mercenaries rather than the missionaries. We are selling medical education but expecting missionaries as a product. Indian government has approved medical colleges for profit, but we are expecting missionaries. This is just a comment on what the previous discussion happened. Your question to me is it only in India that this thing happens? WHO in 2014 published this report that there were, I'll read it out to you, 372 reports of attacks which occurred in 32 countries, and it caused 603 deaths and 958 injuries. It is not something specific to India, but you have to realize something else. Normally, Western literature will describe violence against doctors as 4 types. One is, there is a criminal who comes into a hospital to do some theft and he commits violence because he is caught there. Second is patient related. Third is between hospital staff. And fourth is, like the husband or the boyfriend of a staff nurse comes and conducts violence in the hospital premises. India has the distinction of creating another type of violence, which we call mob violence. This mob violence is generated. It does not happen spontaneously. It is not that one person has died and suddenly 200 people have sprouted. No. This is WhatsApp lynching. There are organizations who are paid, who are doing this as a profession. Whenever a death is occurring in a hospital, the same family of 5 people were denied bail in Calcutta because the police showed that it is not in one hospital. They have been involved in violence against hospitals in 5 different cases. And what they do is कि आपके पेशेंट की डेथ हुई है, 4 लाख का बिल पेंडिंग है, हम नेगोशिएट करेंगे आपके बिहाफ पे हॉस्पिटल से, and you pay us 25% of whatever bill is or whatever settlement you receive. In China also this thing is there. It is called Yi Now phenomena in China. There also for payment protesters are available. And this is what is happening in India. I don't want to name the organization. Punjab is was suffering very badly because of one particular organization. And luckily some stringent actions were taken by the nursing homes and things have been brought under control. But doctors, as has been said, are a very vulnerable target. And corporate hospitals or government establishments form just a very small percentage of the healthcare providers.
You enumerated the types of violence.
Yes.
What do you think are the reasons behind this violence?
There is only one reason. The reason is lack of deterrence. Basically, if you follow what the advice has been given of what is called the broken window hypothesis. The broken window hypothesis is somebody throws a stone at your window, you take action there and then. When you ignore that, you encourage the perpetrator to escalate the level of violence, his criminality. I hope the judicial ma'am will agree with what I'm trying to say, because this is something which is discussed And I mean, sir is a retired Director General Police, so he will also be understanding what I'm trying to say. We need to curb violence with a strict hand. There is no reason. Cost is not a reason. Cost of healthcare not a reason. Why? Why does violence happen in government hospitals? Cost is not the reason there. The simple thing is, it is propaganda. One, the propaganda will start that your treatment is going to be free of cost. If I make an election promise that you will get 10 tolas of gold, go to your nearby jeweler and take it, and we will pay the jeweler 1200 rupees per tola, it is a very good election slogan. But if you are not putting your money where your mouth is, it creates a disparity, and the people feel cheated. Ki I expected free treatment, and here I have paid, and then I have not got the desired result.
Ravi, do you agree with him? Or there are some other reasons which you feel that in the perception of the patient, there may be justification of violence?
No, Ashwini, I'll answer here again.
Okay.
The thing is, there is no absolution to be given to justified violence.
No, I'm not saying
Justified violence of any, there is no justification for violence. If you want to say that this person's relative died, and that is why we conducted violence, and so it should be condoned, then, I mean, Indira Gandhi's killers and so on and so forth also should not be prosecuted. They had a justification in their mind.
Mr. Luthra has a point to make.
So I think there are two parts to it. One is, of course, as you've said, organized violence. That's a phenomena which is beyond the contours of a spontaneous act. The spontaneous act occurs perhaps for two reasons. One is, are we communicating? Are doctors communicating? So that's a serious concern from the patient's perspective. The second is a lack of understanding about what occasions, what medical negligence actually is. So the fact is, these two factors combine in a very deadly way and lead to spontaneous violence. And the third is, of course, the financial aspect which Dr. Nagpal spoke about.
So this brings us, yes ma'am.
I'll just supplement what Mr. Luthra said. Most of the cases of mob violence have always been cases of death. Where death has occurred, the family gets excited, agitated. Even during COVID times, it was always where death occurred that families got excited and started using violence against the doctors and the medicos and the nurses, etc. So that has always been a precipitating factor, not normally used. And now I think hospitals, the bigger hospitals, are taking care of it by posting bouncers, etc. Because you need good security agencies also to protect the doctors. So that is also another aspect to be kept in mind. It's not always done without reason. It is, and secondly, I think where there is a problem which I found whenever I dealt with medical negligence cases as a lawyer, I feel that, when a death occurs, that hand-holding of the doctor with the patient's family is missing. They just want to get rid of the body and the family. Some amount of hand-holding is very, very important at a psychological level.
So you say empathy is important,
Yes.
and compassion is important.
Absolutely.
So this brings us to the safety of doctors, healthcare staff, and assets of the healthcare establishment. Now, recent RG Car case has brought some very unpleasant realities, ground realities to the fore. Mr. Vora, I would like to ask you, as the former chief of the police, what is the role of the police in such a case?
The role of the police naturally is to give protection and, of course, then detection and take necessary action as per law. The problem in this country is that these problems occur because police is, occasionally, some people are incompetent or they work under political pressure. Now, this is what happened in the case of Calcutta. In fact, soon after that, I wrote an article also in the Tribune. Now, coming to a larger issue, Justice Malhotra, my view is that the police has become like the private army of the politicians in this country, and all political parties across the board. I will not say X, Y, Z. Now, and that the problem again is in the law. See, according to the 1861 Act, police is accountable to the executive, which means to the government. Now that law has not changed. Of course, after the Supreme Court's directions in 2006, many states have passed the law, but they're more of a whitewash. Now the problem lies therein, and at this Calcutta case which you mentioned, so unfortunate, what was incompetency, second was connivance, and third was the political thing. Imagine when the case was transferred to CBI, the next day the chief minister of the state goes on the street, takes people along, we want justice within days and we want the guys to be hanged. Till yesterday the case was at her doorstep. This is what is happening. So I think going back, I think I'll talk in the reverse direction. First thing is that unless the law changes, unless police is made accountable to the parliament, things are not going to improve at all. And no political party wants this to go. Nobody wants to leave the control of the police. This is one. Second, yes, about incompetence of the police or occasional problems like one we had in Dosa. I mean, you must be knowing that, where the doctor committed suicide very unfortunately. So it was, of course, political pressure because the case was registered, but then, of course, the guy was suspended, the SP was transferred, all that happened. But I would call it incompetence. There are laws, rules, rulings of the Supreme Court, they were not being taken into account. So I'll take that into competence. And this is where I think the police leadership has failed. Let me confess it frankly. Third is, I think, the hospitals and police coordination, their quick getting in touch with each other, having things like, hotlines, maybe use of more technology, calling the police at once. In each hospital, as you know, there's just one constable only. Just one constable, medical legal guy who doesn't know much about it. So I think more of interaction with the police is needed. PCR vans maybe can be stationed there all the time.
So can you put this
Which can be, which they can attend to other situations also.
Mr. Luthra
So
wants to
brief,
interject
yeah.
here.
So I just, there is a systemic issue with the police, but the point is, in case of a crime, there are two levels of action which can be taken. The first is, the police can, in a case of violence, register information, catch the culprits, prosecute them, and also, as a precautionary measure, ensure there is patrolling. You know, we've had a very healthy system in this country of beat patrolling, even in residential areas, which is preventive policing. So I think it is now time in these matters to have a look at preventive policing along with reactive policing. So reactive policing is going to obviously happen after the event. But that preventive policing, that mechanism where the beat constable would visit every establishment, residences, watch localities, and there was a very wide, strong network. That has to be put in place because that will ensure that if any incident is about to take place, the beat constable, which should be in the area, should be able to call the necessary resources. Also, technology needs to be applied so that you have these quick response team vans and others, that in the event of an incident, there can be an immediate response to any incident.
No, so you're talking about the preventive policing, but the reactive policing also, when there are, say for example in RG car case, or there are multiple cases where there's delay in filing FIRs.
So I have answered that already to you. This incompetence, connivance, if you mark my words, what I did say, and the political pressures. But I think Mr. Siddharth Luthra has made a very important point of beat patrolling. That system was very good. It has gone, God knows, vanished even in the streets also these days. Yeah, it may not be a bad idea that in the hospital also one or two constables in uniform, they may go around, especially the OPD area.
So if there is, so I'm asking you, sir, that in case there is a delay in filing an FIR, what happens to the evidence?
Yeah,
Well,
tampering and destruction of evidence happens. But there is one aspect which we also need to keep in mind, that under the Indian Constitution, law and order, police and hospitals all come under the state list. It's there's specific entries, so it's obviously the central government which can't take responsibility.
Right.
So it has to be done at the state level. So that is one issue. Insofar as the RG car case is concerned, my views are that I don't think there was any lack of laws. Of course, there was a great delay in the registration of the FIR, and from what we read from newspaper reports, destruction of evidence, etc. But I will not comment beyond that because the matter is under investigation by the CBI. I won't opine on that. But insofar as the law is concerned, when a case like this takes place, what it has revealed to me is the complete lack of basic facilities for women doctors, in particular in government hospitals. There is complete lack of facilities. It's not that there is lack of laws. The two laws which really are relevant, one is prevention of sexual harassment in the workplace, and the second is it's actually a case of rape and murder, which preceded the other. I won't comment on that, under investigation by the CBI. But the point is, so the criminal laws are in place. There's an FIR registered under investigation, and second is the Sexual Harassment Act. What I feel it has revealed is that there is no proper patrolling, no proper place for women doctors to rest after a long hours of work. There's no surveillance, nothing. There are many entry, exit points, people entering as they like. And, there was such a large fund which was created by the central government of about 7,500 crores as the Nirbhaya Fund. I don't think even a fraction of it has been spent on, providing safety for women doctors in hospitals, government hospitals specifically. They didn't even have a separate block of hospitals. For instance, the Aruna Shanbhog case is one of the most terrifying cases, where there was this nurse and there was a sweeper who raped her, and he took a dog, chain and put it around her neck and twisted it so that she would not, be able to protest and then in the process, when he twisted the chain, the oxygen to her brain, snapped, and she was in a permanent vegetative state for 42 years. And her caregivers were the hospital people, even the family could not, take care of it. So, and there are many such cases which are reported, unreported. It really shows lack of basic facilities in these hospitals and low prioritization in the monies being expended on this issue. Completely low priority. If you go into the statistics, you will find that out of the 7,500 crores central government has given to states, I think hardly even 1% has been used for improving these facilities for women doctors.
Well, I'm reminded of another case also from PGI Chandigarh where
Yes,
where
that's
the
right.
acid was thrown
Yes.
on Dr. Neelam Marwaha.
Right.
And so similar cases, do you think our existing laws are sufficient, or they need to be amended, or you think we need to get new laws for bringing the culprits to the book?
Insofar as that was a case of an acid attack by a senior colleague on a junior woman colleague, it's one of the saddest cases I think I have read about. It's a blood-curdling case. She has been permanently debilitated. Her entire body has been disfigured because he poured acid right from head to toe, dragged her by, her hair, all through the laboratory where he had poured acid. But I think now the law has been amended. Even in the latest BNS, there are now, specific
Section
provisions.
124 is there.
Yeah, but I'll tell you where the failing arises. The failing arises even though the Delhi High Court had passed a judgment. The point is that acid is easily available even today across the counter. And the guidelines which the courts have framed, they are not being implemented. The point is that acid is used as a detergent for cleaning toilets and various other things. So therefore, there are alternatives which are required to be found. So it is really a very, very serious and trying issue because the number of acid attacks, I was going through the statistics, has increased. So, much more needs to be done because particularly in an acid attack, the treatment is far more expensive because it requires plastic surgery, the muscles get burnt, and a person gets permanently disfigured and debilitated. So their rehabilitation becomes very hard.
Right.
So these are serious issues.
Mr. Luthra is raising his hand, and then Neeraj also wants to interject
So
after that.
the laws
Yes,
are
sir.
comprehensive. It's not that we lack laws. After the Nirbhaya case, we got the 2013 amendments. and yet you have had incidents of rape and murder. So there are two levels which we need to look at this. One is the policing level. Police reform, modernization, upgradation is definitely essential to ensure a safer society. We can't also turn it into a police state. At the same time, what is also needed is, are establishments investing enough in ensuring the security of their personal men and women in the establishment? You find there is a level of outlay at private establishments, but government, despite the availability and access to funds, is not putting the necessary fund in. Justice Malhotra spoke about the Nirbhay Fund. It remains sadly unutilized. And it's not that you can't have, and you talk, and just to add one point about reactive policing, I prosecuted the Nirbhay case till in the Supreme Court as well. And I must tell you, it was one of the most scientific, logical investigations that I've come across. The question is, despite the new reforms that we brought to the criminal law, are we having the infrastructure to replicate that level of scientific investigation? And that's the question. To begin with what you said, delayed FIRs are going to make you lose evidence, both exculpatory and inculpatory, both guilt-related evidence and innocence-related. So we have to begin by ensuring that the criminal law is set in motion at the earliest.
I would, because we are running short and because we were started little late.
Can I just make 2 points?
Sir, very quickly.
Yeah. See, hospitals should have a security audit, I think. This is very important to the present scenario. They should all have from security professionals so that they can give some guidance, some advice, because they are professionals in that particular field. Sensitization of the hospitals are also required. In this case, for example, Ka's case, there was so much delay, and maybe because there was vested interests also. Now about the last part, in the UK now recently when they had these demonstrations, I think within 2-3 weeks people were sent to prison for 20 months. I think the British who gave us the laws, we are still sticking to them, but they are so nimble-footed, they keep on changing their laws and all. But this is generally, of course, at a bigger level that I wanted to say. Thank you.
Right. Mr. Luthra, I'll come to you, Neeraj, a little later. I wanted to ask you something. The perceived medical negligence has been quoted as one of the causes of violence. But what are the remedies available to the patients, legal remedies available to the patients against the medical negligence part?
Well, one of the horrendous remedies is that now doctors under the BNS are liable to be prosecuted. That's one problem. It's unfortunate that the legislature thought fit to specifically bring into effect an offense in relation to doctors, though the other part relating to motor vehicles has not yet been notified, 106 Part 2. 1. So there are criminal liabilities. Patients can, let's say there's a case of miscarriage, there are provisions relating to miscarriage, there are provisions relating to hurt, provisions relating to death, 106. So that's one part under the IPC. There are also remedies. Now this is the catch. Dr. Nagpal is here. The MLAG and we are trying to, after the D.K. Gandhi judgment, trying to get clarity in the law that the new Consumer Act, Protection Act, should not apply to doctors. That's a process. There was a misfire when we went to the Bombay High Court and we didn't succeed in the Supreme Court, but we're trying to get that clarity. Needless to say, consumer laws are available to a patient, and thirdly, patients can always file civil suits in complicated cases. So even otherwise, they can make their claim in damages because consumer remedies are an alternate to civil claims for damages.
Ma'am, let me come to you. Do you think it is appropriate for the doctors to be prosecuted or tried under Consumer Protection Act? Is it appropriate?
It is my firm belief that doctors cannot be tried under the Consumer Act because I feel the members are not equipped to try and adjudicate these cases because these are certainly very specialized in nature. In fact, whenever I used to appear in the National Consumer Disputes Redressal Commission, I always had the doctors sitting by my side. I said, you please lose one, operation a day, but you will have to be available. That helps a lot because the members are really not, equipped. And I think the best experience we had was when a member, Ms. Dr. Kantikar, was on the bench, medically equipped, and I thought he did justice. I don't believe that he ever was unfair in his adjudication. So it's essential that specialized tribunals are set up. And in the meanwhile, during the interregnum, in the present scenario, I think that the president and the members should be advised to appoint doctors or medico legal experts as a amicus curiae to assist the tribunal to adjudicate these disputes fairly. Because even I'm not a doctor, didn't understand the nuances. I read the file from cover to cover, but I had the doctor sitting by my side, because all kinds of questions arise when you're doing a case,
Right.
and it helps a lot when a doctor is sitting by your side and who's done the case. He understands and he explains it even to the bench sometimes. So I really believe that the present constitution of either the National Commission or the state commissions are ill-equipped to adjudicate on these technical disputes. And they cannot, be put at par with a consumer dispute. If
Right.
lawyers can't be, nor can doctors.
That's very heartening view from you, ma'am, as a judicial officer. Siddharth, may I ask you?
Add one more point. I also believe that retired judges by themselves are really not equipped to adjudicate until they get medical assistance.
Very quick, Ravi, you wanted to say something.
That is really very heartening to hear. I think it's absolutely necessary for each case to be looked at independently and by an independent expert. And I think unless you have that independent expert's report, not the expert hired by one side or the other, the independent expert's report to assist you and somebody sitting next to you to guide through the process, I think I can't see how people can say that the justice has been served. It has not been served. So that's very heartening to hear. Thank you.
In fact, I do want to say that, if it was always that I had a doctor to assist me in all my medical negligence cases, whether in the Supreme Court or National Commission, and we never lost a case because I got the proper assistance. Without assistance, you can make mistakes yourself.
We come to the criminality and doctors, and Mr. Luthra, you mentioned about the BNS being there. I would ask you a most basic question. When the edifice of criminal law rests on something called as mens rea, which means the law presumes, correct me if I'm wrong, law presumes that the crime has occurred in the mind of the person who perpetrates the crime. So do you think the doctor really is of guilty mind?
In fact, that's the reason there is what was called a general exception earlier. There's an exception in the law which says a person doing an act for the benefit of somebody, if they cause harm while doing that act, would not be liable. There's an exception. There's also an exception that an accident is not criminality. So these are two things which you must keep in mind. However, if you recall the Jacob Matthew judgment, and that principle will hold good even under 106, that there is a case of gross negligence. So the grossness test has been applied. That is to say, let's say a doctor who is to do a surgery does it under the effect of intoxication, or a person who is not qualified to carry out an endoscopy chooses to attempt that. So these are issues where criminal liability may arise, if at all. That's the, I'm giving you two illustrations, but that's the kind of thing. So one thing I'll explain, there is rashness and negligence. Negligence is in the doing of the act. Rashness is doing something, let's say, beyond your competence. In Singapore, they've actually made a distinction between these two elements in their version of the Indian Penal Code. We have still chosen not to. We could have, but we've lost that opportunity so far.
Britain also, they have differentiation between negligence, gross negligence, and manslaughter. So that's thanks.
So you were mentioning action taken in good faith and the exceptions, etc.
Yes.
Chapter 3, Section 26 of BNS say that should it not take precedence over the other sections like 1171 and 124, where the vegetative state being caused by one of the acts of the doctors who doesn't know how to happen, and then he may, after twisting, I'm sorry, but both sides of the lawyers would kind of, can twist it whichever the way they wish to.
I would say interpreted, not twisted.
Okay.
But
All right.
I will tell you, about 20 odd years ago, maybe longer, Justice Malhotra used to ask me to assist her in medical negligence matters. And I must tell you, there are rare cases of liability, very rare cases where liability is imposed. When is criminal liability imposed? I'll tell you simply. One of the instances where liability is often imposed is when the documentary records of the treatment, which used to be a situation in the past, were problematic,
Yes.
or when there was an attempt to cover up. Those were the two areas. The third was only those very rare gross negligence cases where you choose to not even bother to count that you left a scalpel in somebody's stomach. Now, these are those exceptional cases where criminality may be attracted. In most cases, forget criminal prosecutions, consumer cases end in a dropping of proceedings against doctors if appropriately handled. The difficulty that arises, and I've hit my head against many walls over many years, to say, when, if I have a problem, I will call Dr. Setia. But if Dr. Setia has a legal problem, he may say, this is a small issue, I'll handle it myself. That mindset has to change.
So you need basically medical
No, with
legal
us it doesn't-
experts.
Between us, it doesn't matter.
Sir, I'll ask you, Mr. Vora, can a police official be held in contempt of court if he ignores the established principles as established in Jacob Matthew case, for example, that you cannot arrest a doctor in a routine manner, but we see it day in and day out. The doctors are arrested, FIRs are filed beforehand. Even Justice Sadashivam in one of the judgments said that you cannot routinely file an FIR against a doctor. So do you think, it's a provocative question, but do you think?
So the contempt of court, of course, I think is something which may not even come out, because there are enough laws. The laws of the land itself are enough, even for the police officers. Even there's death in custody, they are charged under murder. They are charged under 302, and normally action is taken. Like I was referring to the Dosa case. So I think contempt of court will particularly, how will it help? I am honestly not clear, but I think there are enough provisions already to take action against police officials who take action mala fide that way. Yeah,
I think
that's more than enough. I think.
contempt is slightly different. The issue is this: are there consequences of breach of the guidelines in Jacob Matthew and legal consequences?
Fair enough.
No, I'm just fine-tuning this. So I'll just to add to what Mr. Vora said. Now there is the judgment in the case called Satyendra Kumar until insofar as arrests are concerned, and wherever for offences up to 7 years where the requirements of section 41A, that is a notice before arrest, is not followed, it leads to disciplinary action and bail is to be granted immediately if such a breach takes place. The Supreme Court is actually monitoring this, and directions have been issued state-wise, both by the state governments, most of the states have issued directions, to the DGPs of police have issued directions to ensure that the necessary safeguards in all offences punishable up till 7 years, which are most of the offences relating to doctors. So they're all, in that sense, covered, and I can tell you, disciplinary action is being taken against police officers.
All right. My next question would also be, because of purely the nature, would be directed to you. So many a time, we find that intensivist grapples with a case of end-of-life care, right? Whether to pull the plug or not. And as I mentioned in my setting of the context, I would request you to enlighten us about the law here.
So two parts to it. There is regulation 6.7, which I believe is still valid, 2002 regulations, which is still there. I was looking at the common cause judgment, which is on living wills, or rather the advanced directive, that really doesn't deal with regulation 6.7, though broadly it deals with the issue. So the point
Would you briefly
is,
elaborate what is that regulation?
I'll just tell you. So regulation 6.7 was that if a person is brain dead, you can actually, with the committee of doctors in the hospital, can take a decision to withdraw care with the consent of the family, withdraw a life support. So that is one aspect of the matter. Unfortunately, something which most people don't read. And when the common cause case first started, I brought it up to the court that Aruna Shanbag didn't deal with this issue. The common cause case is a second case by 5 judges of the Supreme Court, where there was a talk of a desire that a living will concept be brought in, but the Supreme Court has brought in a mechanism through Supreme Court directions that there can be an advance directive. That is to say, I can say that if I'm in a terminally ill state, I can mandate that end of life support can be removed, and then there are steps if life support, if the person can change their decision if of a fit mind. So those are mechanisms. To come back to the original aspect, what does an intensivist do? So the point is, if an intensivist is going to just withdraw life support of a patient, it will lead to legal consequences. I personally faced a conundrum a few years ago. I was looking after one of my late teachers who had adopted me a son, but I was not a blood relative. Lady was in Max, and the doctor told me, he says, Siddharth, you're the one looking after her. She's now reached a stage where we can't do much for her, but the family was not willing to respond. Finally, she passed on in natural circumstances. But the point was there was a conundrum and the treatment went on for weeks. She was just on life support, lying there lifeless for weeks.
So the answer to your question is that the intensivist cannot do it suo motu, and he should never do it suo motu. It has to originate from the next of kin and family. And now the court has put certain safeguards, because sometimes a next of kin may be just one person,
That's right.
and they may have a vested interest in putting an end
Yes.
to the life of
We
the
see it day in and day out, ma'am.
Yes.
Yeah, I'm very sorry to say, but we see it day
No,
in and
no,
day out.
it's a reality of life.
Yeah.
So that is why Supreme Court has said that there should be a body of doctors, etc., take their advice, etc. But this, I think the advanced medical directive is also useful, but that's also more for the educated and literate people. People who are not educated, really would not know about it. But advanced medical directive is, a good way out, that if I ever, get into a vegetative state, please don't, continue with medical treatment.
Yeah, please, briefly. Yeah.
Yeah, the practical thing is, doctors record it as left against medical advice, but even that has led to consequences. In Fortis, there's an issue which is pending where a child was sent off and the child passed away in the parking lot, and that matter was pending and went up to Supreme Court.
Right.
So these are issues of concern. Intensivists can't just act, and even if they have to get consent of family members, it's better to act as per the law. We've told you through the directive and 6.7.
I would ask you about the measures to avoid all that, but I think that is beyond the scope of today's discussion.
Just one last addition to what Mr. Luthra said, that even when you take the consent, please have it witnessed by independent experts.
Right.
Always have, whether it's a consent form, because these are medico-legal documents, they must be witnessed.
Ravi, do you have something to say? Because you being associated with critical care transformation and integration, being director there, and you've been there in England as an anesthesiologist and intensivist, do you have to add something to it, or you have some other kind of dilemma that you face?
No, I agree. I think the two things here. The principle is that you will not offer a treatment to the patient if it's not going to be in the patient's best interest. I will not give you a tablet for headache if I know that that's not going to help you. So when you reach a stage where medical treatment is of no benefit or it's not going to help the situation, you've made that decision in your mind, but then it's quite a big decision. You have to have body of opinion to opine with you. So before I would reach or talk to the patient, I would talk to few of my colleagues, maybe from different specialties. If it's patient come from renal specialty, I'll talk to them. 3, 4, 5 people agree that the treatment is of no help to the patient. That is what you put to the relatives. And the relatives then, or next of kin then, have to come with a judgment, with a decision, or with a second opinion, say, they may want to take second opinion. I think that is where sometimes let 24
But you
hours
would need
pass.
to document that
Less
very
48 hours.
clearly. You would
But
need to document that very clearly.
Exactly,
Absolutely.
that's what I was just going to say, that
Document.
it must be documented.
Absolutely.
And all the doctors who've participated in the decision
They
should
have to.
sign it.
They should sign it, and once that is done, and then you ask if the patient's relatives come up and say, this is, since it's not adding any value, treatment may be withdrawn. That is the stage. So as an individual, I wouldn't take a decision entirely on my own, even if it's my opinion. I would corroborate, I'll make sure that that is what has happened, and then the relatives themselves feel that that is how it is.
And give the option to the relatives
Yeah.
to take a second opinion if they wish.
Yeah.
So that should be documented that this is the state of the patient. And you know, if you wish, then you can proceed. Otherwise, because documentation is key in medical negligence cases, because that is contemporaneous record of what transpired. Because later on, when cases, are filed and they come up for final hearing, the doctors, court says, but where is this documented? So, and I know 2-3 leading doctors whose cases I've done, they were very particular in not only documentation, but even videographing.
Right.
So today it's become very important to maintain contemporaneous records. And the second aspect, which is very critical, where I feel doctors fail, is that they are in a hurry to leave. So they don't document it. And very often I found that there was a discrepancy in the nurse's notes and the doctor's, writings. So one has to be careful because documentation is what, really saves the doctor.
Mr. Luthra, do you agree or do you disagree?
My point is there's a distinction between the practical, as Dr. Mahajan said, and Justice Malhotra said, and the legal. Legally, either the regulation or the directive, there is no, and I would suggest you circulate the directive, the judgments, directions to all your members. There are only 2 ways out. Practically, what happens is exactly as Dr. Mahajan and Justice Malhotra said.
Right. So
That's the
towards the
that's
end
the
of it,
safest.
I just changed tack completely, and instead of, from the criminality, the civil, the Consumer Protection Act, etc., I come to social media, because now social media has become a ubiquitous part of our lives, and we use it for our telemedicine purposes, and there are other ethical issues involved with it. So I would like to ask you, Ravi, what do you think about who should be responsible for the data breaches, and what do you do when somebody trolls you on that, as a hospital, as a doctor, and so?
I don't have a very clear answer to that. I think this social media is such an uncontrollable and you see it against anybody and everybody, and also the doctors. The Twitter and the tweets and things on Facebook. As a doctor, if some patient goes and tells something, writes a report or writes a comment, how can I take it forward? Either I spend my lifetime.
So you think you should
in
ignore
chasing
it?
I would choose to ignore it personally, and that in a way may not be the best option, because then I am allowing it to, But what do you do? Do you just carry on with your work, or are you going to lose your sleep over it?
You can get a gag order. You can ask for a gag order. If proceedings are pending, easily. If not pending, you can file a civil claim and get a gag order and ensure that there can also be a takedown of offensive material.
You should also be ready now with the AI coming up, the deep fake, Doctor's face can be duplicated,
Sir,
and you can some damaging statements.
With the coming of AI, the
Yeah.
credibility of anything virtually is non-existent now. You don't know
That's
what is
true.
being said by Trump or by.
But I do hope, Dr. Satya, that now the Honorable Supreme Court had appointed this committee, after the Ajikar case. 2 months are over. Hopefully the report would have been submitted. But I'm sure all of you concerned would have given their recommendations or memorandum or suggestions to that.
Right.
Let's wait for that. I'm sure something good will come out of it.
We've already exceeded our time with that. I think we come to the end of the discussion. If the audience has any questions, the experts would be most happy to field.
Or as to Siddharth said, for the Fortis case you briefed upon. So my question coming to this content is the medical negligence the reason for the conflict that happens? And if yes, who makes the audit for the medical negligence?
So who decides it is medical negligence? It is the perception of the patient that there has been some medical negligence. Let us
Unsuccessful
first
outcome.
define what has happened is a medical accident, if at all. Who is to blame will come later. But when you conduct violence, that is a criminal action which you have no justification for. And both the things need to be prosecuted separately. They have to be distinguished. If you think there is negligence, whether it is civil negligence, prosecute it. If you think there is criminal negligence, prosecute it. But that does not give you the right to commit violence. That violence has to be suppressed with a very, very heavy hand. Because when you conduct a violence against an average person on the street, it is IPC or BNS which kicks in with its various sections. But supposing that person is a pilot, and while I'm going back to Chandigarh, he's flying my plane, and I go into the cockpit and I beat him, would the same sections of BNS be applicable? Because now I'm endangering the life of 200 other people. This is what happens when you conduct violence in a healthcare setting where not only the doctor, but the care doctor was giving to other patients becomes substandard or deficient for at least some time. That you have no right to take because this is a fundamental right to life. Under fundamental right to life, right to healthcare has been included. So if I'm treating 50 patients and one patient dies and his relatives are beating me up, the other 49, this patient who's beating me up has no right to make them suffer. I hope what I'm saying is correct.
Sir, in revert to it, if there is a crime or violence being created into the setup, so how the hospital can claim the price for that the violence has been created? So
Why not?
So it is to the patient or to the attendant? So to whom to pay?
सर अगर किसी को लगता है मैंने कुछ गलत किया है वो मुझे स्यू करेंगे. अगर हॉस्पिटल को लगता है XYZ has caused me damage, the hospital will sue that XYZ, whether that is the patient or the relative. But we need
the
to
reasoning
identify
is
who the perpetrator is.
Sir, but the reasoning will come always that I have not done it.
Right, so I think we can discuss that on,
modality,
we cannot have an ongoing discussion. Yes, sir.
Yeah, so I have a question that so far the removal of life support is concerned. Once that patient is declared brain dead, after doing 2 apnea tests, so what's the rule says? Because he is scientifically dead, and he cannot occupy
So
the
then-
ventilator,
then
which
the,
is
the hospital should have a board of doctors which determines that he is brain dead and then advises the parent and with the consent of the patient's family takes the decision to remove life support.
so is it required to get a consent because it is already declared brain
No,
dead by a
sir-
committee?
Sir, the consent will always be necessary of the family members if available. They have to be family members. There's no family member, it's a different matter, but consent must be taken.
There are 2 hands going up.
I'll
One
give you
is a
another
lady there.
reason why.
I'll come to you after this.
Sir,
question.
in Kerala, there was a case where, with the consent of one brother, this life support was withdrawn. The other brother comes and he files a case that this hospital, without conducting an EEG or some other test they had mentioned, have declared my patient brain dead simply to salvage the organs. You get my point? So there is allegations both ways. So consent is mandatory, even though you may have decided medically that the patient is brain dead.
Sir, I think I'll stop that discussion here because we are far exceeded. The next session is going to go on. Very 2 brief questions. First the lady and then Shochin.
Thank you so much, sir, ma'am. Actually, I don't know if I have a question, but I do have some expressions here. I was looking forward to this session immensely because I'm a girl, I'm a doctor who's been in this system, and I have faced a fair amount of, all of this legal system and otherwise the harassment and everything all through my career so far, especially in my medical college time. So thank you for highlighting a lot of those points. I think, correct me if I'm wrong, that's all what I want to walk away with, that there's a lot of accountability that has been sought from doctors, from the medical system, probably from the judicial system as well, from the law and order as well, sir. When do we get together and probably seek the accountability from the political system, which some of you have already mentioned very loudly, but probably never reaches the podium which it does, because that is probably the only factor which leads to the vulnerability of the entire best of the best people or leaders who want to probably do the right but are not able to do in a totality. So where we talk about Nirbhaya, whether we talk about Arjikar, whether I talk about myself, every time something like this happens, there's a lot of anxiety in me. It takes me back to probably my personal incidents, which takes a lot for me to even fathom, because currently I'm taking care of a DMB program for Apollo Hospital. And I have young doctors who are reporting to me, who come to me and they genuinely want to share their experiences. But that's one part of it. I think I agree with you, sir, Dr. Neeraj, that the definition of medical negligence given in the Google or Wikipedia is definitely there, but the understanding of that for doctors is there, but probably the understanding of that to a layman has never existed. It will not exist, because constantly there are perpetrators who are actually making sure for their better interest that the tolerance is converted into intolerance as the years go by. And that is why we do not reach a point where there could be any possible solution or a complete solution. So thank you very much. I'm
Thank you.
sorry I did exceed my point.
Thank you,
of time.
ma'am. Last question, brief, Mr. Shuchin.
Thank you very much,
Dr. Shuchin.
ma'am and sirs, for a wonderful, wonderful panel. Really, really enlightening. Nagpal sir, you said that, it's very simplistic to say it, I guess, that if I have done wrong, you sue me. If you do wrong, I will sue you. My question is to Justice Malhotra and Mr. Luthra. How do we build this trust into the doctors as well as the community that if I have been wronged, I should sue you? Because we've always heard justice delayed is justice denied. And we keep hearing this, that even FIRs are not filed in time. Cases take 20 years to come in, to get solved. There is no decision, appeals, dates. What is the legal system of India doing? I recall a time when the Aam Aadmi Party government had just come into power the first time in Delhi, and they had talked to the Chief Justice of the Delhi High Court, the law minister, on how we can expedite. And there was a big hullabaloo over, how can the executive even talk to the judiciary on how to expedite the legal matters. So what is the legal system in India doing to solve for this major issue that we face on a day-to-day basis?
So the first thing you have to understand is there is the docket explosion in India. So people often turn to alternate methods, whether it is physical violence or extraneous methods outside the legal system, because they feel that the legal system does not provide them justice with the necessary speed. Can it be done? The answer is yes. I think we've reached a point of time where we have two levels of challenges. The first level of challenge is infrastructure issues, which is really the number of judges we have from the trial court upwards. So we have to really, as a system, we have to relook at how fast we appoint and what is the judge individual ratio in a country as large as India. That's one of the crucial things. The second thing is there are bottlenecks which are getting created in some areas. Those bottlenecks need to be addressed. And the third issue is that we have been evolving with an attempt to find solutions. For example, the traditional way in the High Court and Supreme Court used to be that matters used to be admitted and essentially go into cold storage for 8 years, 10 years. Now judges seek to put matters on, let's say, Tuesday and try and hear them. And out of the 3 days when final hearings used to take place, now 1 day they take place. Perhaps it's going to become 2 days soon in the near future. So the attempt is to try and expedite the justice delivery system. The difficulty is it is a multi-pronged situation which has to be dealt with, and we have to have a remedy, and it's something which will require greater contemplation both at the Department of Justice and contemplation in within the judicial system, and accompanied with the accompaniments of the judicial system, which is the investigating agencies, the police, for example. So, it's a, sorry? Political will. Yeah, so the issue is there have to be these three. The political will, of course, is something we always hope for, but that that we can, and that's for us to bring about. But it's a complex situation. There is no one-size-fits-all solution. You know, a lot of people tell me often that why don't our judges go and examine the way the US Supreme Court deals with its docket? Well, the US Supreme Court deals with 8,000 cases, out of which they select possibly 80 to deal with in a year. In our Supreme Court, you deal with 70 cases on a Monday and Friday each. So it's a totally different ballgame, keeping in view the population. It has to be a more comprehensive look, and we will have to really develop and work towards a justice delivery policy, not over a 1-year period, but over a 5 to 10-year horizon. And that is something which is really the need of the hour.
I hope we can have a panel discussion sometime else for the solutions of the question that we've raised, right? Thank you all for your kind attention, and I thank my panelists from the bottom of my heart. I'm grateful to them, indebted to them for having given their expert opinion and thoughts to us. Thank you so much. Thank you.